The next matter is freedom of speech, which is... The Americans have a very strong guarantee of freedom of speech that in the First Amendment, Congress shall make no law abridging the freedom of speech of the press, originally intended as a restraint on the federal authorities only, not on the states, because of a fear a number of states wouldn't sign the Constitution until there were further restraints on this new federal authority, hence the Bill of Rights. It's not absolute. It's famously said that falsely shouting fire in a crowded theatre, that's got a crowded theatre, would not be protected. In Australia, we've developed, the High Court has developed a freedom of political communication. And it finally worked out what that meant in a case called Longy. That's the New Zealand, former New Zealand Prime Minister and the ABC. He was suing them for defamation. That I put in an amicus curiae brief for the Press Council in that matter, which is interesting to appear in the High Court. And the court came to the conclusion it's not a personal right in Australia, but it's a restriction on the legislative power of the states, on the federal parliament. So we do have a limited freedom of political communication in Australia. Is that sufficient?
I have a thought on that. I tend to prefer the American style, where there is an ultimate freedom of speech, although I think they've read too far into it, where they almost go to a freedom of expression, even to things that are sort of, rather illicit and obscene and sort of protected, supposedly anyway, under freedom of speech. But I think that in Australia, the other thing that we need to be careful of is that we don't go too far into the reverse. And we've seen this where people have a right, almost an implied right, not to be offended, which I think is the bigger concern. So where you find that balance, I'm not sure, but I'm certainly of the view that where you have a right to express yourself and someone else takes umbrage to what you have to say, that's their problem and not mine.
I personally think to protect our freedom of speech, 18C of the Racial Discrimination Act's got to be repealed.
Any views on that? Just agreement.
Well, as well, I think that it's a fundamental thing in any liberal democracy, freedom of speech and freedom of or right to own property. Between those two things, it's a pretty good recipe for success.
Well, one of the arguments in the current plebiscite is that there should have been some expression, some legislative expression of freedom of speech before the plebiscite was brought in. But of course, if it were just legislation, it could always be changed. Should there be a constitutional guarantee of freedom of speech, an express guarantee as in the United States? I think so. Anyone challenge that?
I suppose what I would, the thing I'd point out to Jai then is not so much whether you think, what rights you think people should have, but at the end of the day, if you're committing it to the Constitution, the real decision is, do you think that the Parliament that's accountable to the people can make those political decisions best, or do you think that the justices of the High Court can? Because that's what it's going to come down to when you put it in the Constitution. It's going to come down to, you're going to have to make a decision. Do you leave it to Parliament to make those sorts of political calls, or would you prefer to leave it to the High Court? And that's the fundamental issue, I think, when you're going to put anything in the Constitution now, particularly given you've seen how the High Court behaves now. So if you give it any additional power, you understand it will exercise that political power along the lines it's already indicated it's prepared to.
The real danger, as I alluded to, is that you go too far when they do interpret it, and we've seen that in America and the examples that I was giving there. So you are right; it is dangerous that they'll read too far into that. But as a matter of principle in itself, I think that we should be afforded more protections. Whether putting it in the Constitution is the right way of doing it, or some other mechanism, but I think that we don't have enough protections for that.
Damien makes a good point in that it's very difficult to reverse a decision of the High Court, whereas it is easier to reverse an act of Parliament. It can be repealed if the people don't want it. Very hard to change a decision of the High Court once they say it's a binding precedent, and that's that.